Good morning, everyone. I'm Joanne Koontz. I'm here with my partner, Jackie Durham, and our esteemed guest today, Kate Smith. Today is Tuesday, October 19th. Happy birthday, Jackie. What a wonderful thing to do is plan for your demise on your birthday. So like what better could have possibly happened? But
beginning to end.
Thank you all so much for joining us. Today we have a ton of information for you. We try very hard when we make our webinar schedule to include a variety of topics and things that are of importance to our clients. And we like to include things that are outside of our practice area. So because they're still important, and we try to serve as your quarterback and make sure that you have no stone unturned. Kate is one of our tools in our arsenal of estate planning. So I know Jackie's got tons of questions, and I'm sure you will as well. Please use the Q&A box at the bottom of your screen. As always, we will record this and we will distribute it on our YouTube channel, on the KoontzAssociates.com and KoontzParkin.com websites, and on our Facebook page. So without further ado, thank you so much, Kate, for taking time out of your busy, busy day to join us.
My pleasure to be here. Thank you. And happy birthday, Jackie.
Thank you.
So we wanted to kind of get an idea of general estate planning issues, thoughts, planning tips, and we'll let you lead the charge on how you want to break this up in terms of individuals versus businesses. I see Jackie is salivating to ask business questions.
Yes. I'm ready.
Well, I thought I'd start with the basics, which is just what a basic estate plan entails. You might have heard over the years, Susie Orman has always said everybody should have a revocable trust. I don't necessarily agree with that, but a basic estate plan at a minimum always involves a will. Some people will be confused and think that if they have a trust, they don't need a will. That's not true. So a basic estate plan is going to include, at a minimum, a will, power of attorney, a healthcare surrogate, and possibly a living will. I combine those both, a healthcare surrogate and a living will, into one document, which is called a healthcare advance directive. And then also a declaration of pre-need guardian, so that if anybody tries to impose a guardianship, you have a document that demonstrates to the court who your choices of your guardian are. And then for certain circumstances, a trust is appropriate. Now, the trust can come in a form as a standalone trust, like a revocable trust. I don't think a general estate planning, I don't want to really get into irrevocable trust today, but I want to recognize they exist. And sometimes a revocable trust might be more than a client is ready for. But if a client has minor children where they stand to receive, at a minimum, their will needs to contain what's called testamentary trust provisions. So you're going to have a will, may or may not have trust provisions in the will. You may or may not have a trust that works in conjunction with the will. And then you should always have the power of attorney, healthcare advance directive, and declaration of pre-need guardian.
Wow, that's a mouthful.
Yeah, they all have different roles and different people to choose within those roles. So I don't know if somebody has a question before I go into that, because I think trying to figure out who does what and understanding the terms of who does what, it gets very confusing for people. For example, under a will, you're going to determine who's going to be your personal representative, which was once referred to, and in some states still referred to, as executor. This is the person who's going to be responsible for determining all your assets. But it's called marshaling your assets. Go, for lack of a better description, going through your underwear drawer, because it's going to literally. So they're going to have authority to go through everything of yours, and they're going to be the legal extension of you after you pass away. In other states, they still do call them executors. Another person you might have to consider if you have minor children under your will is appointing a guardian to take care of your children, both their person and for their property. I recommend a trustee. So sometimes if you have a testamentary trust with minor children, I don't like the guardian and the trustee to be the same person, because they need to check and balance each other. Yes, unless you have trusted people that you know are only going to do exactly the right thing. And sometimes people are lucky enough to have that.
Yeah.
But I like the check and balance system. And then under the power of attorney, that person is called your agent or your attorney in fact. Now, a power of attorney is a document that's only valid while you're alive. And it allows this person to step into your business shoes. And I'm sure in your business, Joanne, you use them often for real estate transactions, and know that they have to be very detailed in the authority that they give.
And frequently people still try to use them for mom after mom passed away. So
yes.
yeah.
And people don't understand that when the person passes away, the power ceases.
Yeah.
But this gives people the power to access bank accounts and speak with the IRS and file tax returns, file lawsuits, defend lawsuits, sell real estate, handle personal property. And the other document that usually works hand in hand with that is the appointment of your healthcare surrogate under advanced healthcare directive. Many times those people can be the same person or different people, but those two people working together, your agent under a power of attorney and your healthcare surrogate, if they are able to work well with each other, there should be no need for a guardianship. Florida considers those two roles lesser restrictive alternatives to guardianships. So a guardianship is not necessary if your healthcare surrogate and your power of attorney are able to work with each other for your betterment. And then I guess under the trust, we'd have the trustee, which is the person who could, some people don't really realize the trustee could be serving while you're alive, because the trust is operating while you're alive. And then after you pass away, the trustee then makes sure your wishes are honored, whether that be distributing outright to your beneficiaries or continuing in trust. But you can't think of the trustee as simply a person who's going to take over when you pass away. It could be very well that this person, like your power of attorney, is going to be managing your assets for you while you're alive.
Wow. Okay. It's a lot.
I
That is a
know.
lot.
I feel like they need a diagram. But each role, all of them are fiduciary roles. All of them are people you need to trust explicitly. The power of attorney and trustee role are certainly roles that where they handle your finances.
Mhm.
Healthcare surrogate is where they're going to make medical decisions for you. All of them need to be explicitly trustworthy individuals. Unfortunately, as of late, I've had several clients where their trusted individuals have fallen short of their responsibilities, and we've had to petition the court for a guardianship.
Can you tell me if these people all need to live in Florida?
The agents under the good question. Power for the personal representative to qualify to serve. They're really the only ones that restricted as far as where they live. Healthcare surrogate, power of attorney, and trustee, there are no restrictions on where they reside. But for personal representative, they either have to be a resident of the state of Florida, or if they're not a resident of the state of Florida, they need to be related to you or your spouse by blood in order to qualify to serve on your behalf.
Okay.
And the court will appoint an out-of-state personal representative. They will just require a bond to be obtained. So an insurance premium to be obtained for that out-of-state personal representative, so that they have ability, if the personal representative does any wrongdoings, that there's financial ability to make the beneficiaries whole.
Wow. Cool.
And Kate, given how much detail goes into these documents, is there any kind of refresher that you recommend for clients to come back and kind of have a look at their estate documents after a certain period of time, just to revisit and make sure that no adjustments are needed?
Generally, people, I'd say every 3 years or so. Some people think it's done and never look back.
Yeah.
They're happy to live that way. And sometimes it works fine for them, because the documents do contemplate many different scenarios. It's our job to contemplate if somebody predeceases somebody or if something changes. But some of it is so personal, and some of it, I don't think the development in the understanding of the terms of what's in the trust can take time. So I'd say more prudent people meet with their attorney every 2 to 3 years, or even just touch base and say, remind me who's who, and talk about what that person's going through in their life.
Yeah.
and whether or not they can continue to rely upon them if the relationship has stayed the same, or if there's a change that needs to occur.
Right. I know that there's many times trusts that are put in place for, say, children. And at the time it's put in place, you don't know how the child is going to be behaving in, say, 20 years. And a lot of times if, the parents don't want to put restrictions in, that they think will piss off the kid, but at the end of the day, the child grows into an adult who isn't necessarily managing the trust estate the way that they would have hoped. And sometimes you can protect the beneficiaries, I think, in that way by exercising a little more control and modifying your documents, as circumstances change. So just wanted to ask about that one.
Yes, well, and for that reason, that's one of the reasons why I don't encourage my clients to give a copy of the will or the trust, or even the power of attorney for that matter, to anybody. The power of attorney, Florida is a little unique to other states. Our power of attorney is valid the moment we sign it. Other states allow for what's called a springing power of attorney that doesn't come into validity until you're determined incapacitated. We don't have that provision here. So the power of attorney is valid when signed. So it's common practice for an attorney to retain all the originals and be held responsible for releasing them when they're needed. And if a client, it's similar to the will or trust, if a client changes their mind, one, we'd have to get that power of attorney back, and we'd have to notify any third parties who saw it that it's been changed. And two, you've got a child or a loved one vested in what their role was or what they were entitled to receive. But over the years, that could all change. So it's because of that reason I don't recommend anybody giving a copy of the trust, the will, or the power of attorney, to keeping it between myself and my clients, so that if there are changes, there's nobody there with a vested interest to cause issue, because we do all go through many things in a lifetime, whether it be an illness or, distracted with our own children or a spouse, or unfortunately drug, alcohol, mental illness. There's so many things that can derail a person that they should not be invested with your plan until it's time for them to really be aware of everything.
Yeah, and that's an interesting thought too, because when all the Terry Schiavo stuff was going on in Florida, I feel like a lot of doctors' offices, even that I've been to, ask, do you have that? Would you like to give it to us? Like, they're kind of dragging it out of people's hands. And so it might spark, people to take an inappropriate action or something that might not have been ideal. If they had talked to a lawyer first and said, well, yes, I have one, but I'll let you know when I need it.
Yes, the Terry Schiavo case, you didn't have a healthcare surrogate document, but that is the one document that I actually make copies for my clients and tell them to give the healthcare surrogate document out. And I physically mail that to the physicians, because I found my clients weren't sending it to their physicians, so that it would be part of their medical records if there was a medical emergency that they know. But it's common practice here then, if my client updates a healthcare advance directive, we then send the updated one to the doctor, so the old one.
So there's a difference then between the power of attorney and the healthcare directive.
Exactly.
Yeah.
And only for medical emergencies. And that one of people tend to spend as much time thinking about who's going to make healthcare decisions as they do financial decisions, because they're always more concerned somebody's more likely to pull the plug sooner than they would like. I get to know family diagrams pretty well of who's most likely to do it first. Who's not likely to honor it. Because unfortunately, they found more times than not, your healthcare surrogate is unlikely to honor your wishes.
Yeah.
So I tell my clients all the time, the most important thing is the conversation with your healthcare surrogate, and emphasizing that they're honoring your wishes, and that it's a difficult decision, but that they have to put their own emotions aside to do the right thing. Because unfortunately, you'll find within the medical industry, I found through my career, my clients get pressured both ways to not exercise their authority to withhold or withdraw life support, or being told to stop being selfish and to let their family member pass. And that will come from people who have no knowledge of any of their wishes. So the conversation with your healthcare surrogate is extremely important so that they have the confidence and the wherewithal to do what they need to do when if they're faced with that situation.
Yeah.
Does the healthcare surrogate document provide those, a platform for the person to express their wishes? Like, I do want this, I don't want that, but this is the person who will decide if I'm at that point.
Yes, it does. But my form generally conforms with the statute, which is, as you can imagine, is not very touchy-feely, but it does have some points. And for other clients of mine, because everybody's so unique with this, I'll have clients that don't want a living will. So we'll just appoint a healthcare surrogate, and then effectively they've left it in their healthcare surrogate's hands to handle it how they want to without any guidance, because the hospital still may allow them to withhold or withdraw life support. That's not something we can control. And then now I just lost track of what I was going to say.
Sorry. We have a lot of questions.
But what was the question you asked, Joanne, to get me back on track?
So basically what I was saying was, do you provide, like, I'm Joanne and I would really not like to have a feeding tube. Do I get to say that in my documents, or am I just saying Jackie gets to decide for me?
Generally, my form says she gets to decide. I don't want these things. She gets to decide. Other attorneys have like a check box situation. I'm not a fan of check the box, only because we don't know what the situation is going to look like.
Yeah.
Now I have other clients. I have a handful of clients, because there is a following of people of right to death and dying decisions. And those clients, some of them, like, for example, I have a client where I do have a space for special instructions, and I've given special instructions that the healthcare surrogate is supposed to follow these guidelines and then attach the guidelines, which is taken from a book of a gentleman who specializes in end-of-life decision making, that goes through different scenarios if they want that attached. It's really only a small group of people that want that attached. People who are passionate about the ability to make their own choice. I've included provisions like allowing the healthcare surrogate to relocate my client to another state or another country that would allow for assisted suicide. I try to individualize those as much as my clients want or are willing to individualize them. And if they don't want to individualize them, I've had doctors review my form. It matches the statute. So it basically leaves it up to the healthcare surrogate's decision and supports them with their decision to withhold or withdraw life support.
Wow.
Well, it seems like you've definitely put a lot of thought into how you handle those, because it seems like it could get so complicated, and I can appreciate why you wouldn't want to specify in which circumstances they can pull the plug or make that decision, and the other circumstances in which they can't, because there's so many different circumstances that they could find themselves in. It's not always involving a feeding tube or the common scenarios that we hear about on the news or otherwise, but that's definitely, it sounds like one of the more dicey portions of the estate documents.
Yes, and it's one of those things that people don't really want to talk about, but that's the most important talking point. Because if your family and your loved ones don't know what you want, and somebody tries to exercise, there could be a disharmony and disagreement between them, which we want to prevent at any time. But having the hospital, I call it the last man standing rule. Whoever is there with the legal authority to sue the hospital is who they want the signature from. So the person you named has to have confidence to do what they need to do, even though it's the last thing that they want to do. And in some circumstances, it could be temporary. I actually had a nanny of mine, her sister was in a coma for 5 weeks, and they were ready to pull the plug, and she came out of the coma. She graduated from Barry University with honors.
Wow.
and she's got a speech impediment, and she has some issues, but they had thought she was going to pass away. So you just don't know under, any circumstances what things are going to look like, whether or not it's temporary or not temporary, or, and God only really knows. But yes, I try to craft it for each individual client's needs and desires as much as I can.
Wow.
Yes. But like
you're a big bag of fun here on Tuesday morning. Join us next time with Kate. For all your happy thoughts. Oh,
But
man.
it does, it's so nice because it does, at the end of the day, it brings about a sense of peace, knowing that you've covered every rock and every potential, to the best of your knowledge at the time that you're signing these documents. No one can see the future, but at the time you sign those documents, until you go to refresh them in 3 to 5 years, it's nice to know that you've put yourself and your loved ones in the best possible position. So yeah, unfortunately, you have to have these uncomfortable conversations and think about these sad eventualities in order to protect yourself and your loved ones. So
exactly. Yes. And sometimes people, they wait to have the conversations till after they're signed, and then they come back and say, okay, that didn't go so well. That's not the person I want to appoint. So as far as financial decisions, under the power of attorney and determining that person, it's a little easier to determine that person because it's going to be based on trust and capability. The healthcare surrogate is so much emotionally based that could go in a lot of different directions depending on the circumstances. I think getting these things in order too gives you a point of reference as you witness what other people go through in their lives. And as things happen in your life, it makes you think, well, if that happens, how did I address that in my documents? And those are the type of things that I have a client who I think she calls me about every other year, and she just needs to hear who's responsible and who's going to receive. It's so much so that I have it memorized. She can call me in my car and I can say, no, remember, that's your sister and then that's your son, because she just needs a refresher to know. But other people with more complicated lifestyles, it'll be like, well, this just happened. And if that happens under my documents, what does that mean to me? But certainly going through, because many people come in with an idea of what they think it's going to be like. And then after we talk and they hear different scenarios, if they haven't experienced them in their lifetime, it could freak some people out, to be honest, that they never thought that these different things could happen.
I mean, we don't even handle this kind of work, but a lot of our clients call, as you see by how much we send them your way. But people will say, something happened. Someone at work passed away, my best friend's sister, and there was this big problem. And I want to make sure I don't have that problem. So it seems like that spurns a lot of people to action, to say, I was meaning to do this anyways, and I didn't get around to it. But now that I've watched someone struggle, their parents passed away and didn't have any documentation in place. And, it's such an emotional time anyways. And the same can be said for folks that you are anticipating. Maybe they're in hospice and they're going to pass, versus a car accident or something sudden. Either way, you're still grieving, and that's not the time you want to be mired with figuring out who's responsible for what.
No, or if you have a failing parent, their capacity is starting to slip, and whether or not they have sufficient capacity for you to be able to step in as power of attorney and make healthcare decisions, or are you going to go through the expense and the hardship of a court supervised guardianship because you didn't have those documents in place beforehand?
Yeah.
And that's costly. The few guardianships I've been a part of, and that's with knowledgeable people involved, $7,000 or $8,000 just to get them started.
Wow.
And then the guardian's entitled to a fee, and the annual reports have to be filed with the court. And, so certainly avoiding that and having your documents in order. So that's the course of last resort is the best way to go.
Yeah. Wow.
So I don't know if you were planning on touching on this, but I thought I'd just raise my hand about this because I know that some of our interaction with UK oftentimes deals with limited liability companies, because there are folks out there that want to hold their membership interest in a trust. And I know that sometimes there can be certain unintended consequences when it comes to doing so. A lot of people do it, I think, sometimes without thinking about it. They might just quit claim their property from themselves individually into this LLC, and they want to hold it in a trust. And we actually, as recently as a week ago, I think, were discussing the fact that sometimes there's certain reporting requirements, and I think also just the general holding of the real estate can sometimes conflict with, depending on how you're actually holding the real estate, whether it's joint tenants with rights of survivorship or tenants in common. If you have more than one trust holding the real estate or owning the LLC, that many times you really need to have a discussion not only with your business attorney who's forming the LLC, but also with your estate attorney to make sure that the terms of the trust and the way that the LLC and those provisions are going to operate along with the trust provisions is not going to disrupt anything.
Yes, generally the trust should have language to allow the trustee to continue the management of the company. If it has an S Corp election in place, you want to make sure it has S Corp, subchapter S trust provisions in it, so that the trustee can qualifies to serve, qualifies to own the LLC. The actual transfer of the company to the trust is relatively easy. It's a one-page document, but notifying your accountant, obtaining prior consents from other members if you need to obtain the consent so the transfer is valid is always something to be looked at. If it's a single member LLC, it's fairly straightforward and you can assign it without issue of disrupting the structure of the business. But certainly if nobody is informed of the transfer, it can require some extra paperwork on the back end in the event of your passing. But making sure that the trust document allows for the trust to own a company, manage a company, and continue that company after your passing. And then within the trust document, you can even clarify and say, as long as my wife is alive after I pass away, or my husband's alive after I pass away, or whomever, they get to make all these decisions. And I'm not burden the trustee with that. I'm going to let my spouse make those decisions. And then if my spouse passes away, then the trustee can do it so that you can keep control of the company the way you want it to be controlled. And then of course, there's some businesses that may not be assignable to a trust just because of the nature of their profession, like a dental practice. You can't just assign a dental practice to a trust because a trust is not a dentist. So you have to work within the different professions to make sure they qualify, or to have qualifying entities owning the dental practice that then gets transferred. That gets a little complicated, and that's why I refer it out to people who specialize with medical clients.
Yeah, and I know that a lot of operating agreements have restrictions against the transfer of membership interest, and in the event there's some transfer of interest by operation of law, say upon the death of the original trustee of the trust, typically they would contemplate that because their trust is holding that 50% interest in the LLC, that upon their death, the trust will continue to hold the 50% membership interest, and that the new trustee will be able to act on behalf of the trust. But many times what will happen by operation of the operating agreement provisions is that they no longer hold a membership interest. They just hold an economic interest. Therefore, they don't have voting rights, management rights, things like that, which is why I'm raising my hand, because I feel like that sometimes is an afterthought. And I think folks really need to make sure that they're taking a look and crafting their operating agreement specifically to make sure things like that don't happen if you're going to be holding that membership interest in a trust. And even if we don't have a trust present, I also feel that in the instance where we have a limited liability company or a corporation and there's family members involved, if they have a specific estate plan in place, I almost think that the governing documents should mirror the other distribution of the estate assets. So if you want your estate to be administered in a particular way, I think maybe the operating agreement can also be crafted to make sure that if Susie predeceases her brother, that this is how her interest will be distributed amongst the other remaining members, things like that. And I think it would be really beneficial if folks could kind of get their estate attorney and their business attorney together to have that discussion, because it can make things go a little more in accordance with their desired estate plans.
I would agree with you, because otherwise you have two different people who maybe never spoke to your professionals, never speaking to each other. One day you pass away and each of them have, to know whether or not they each understand your wishes, and that the lack of confusion, if everybody's on the same page, versus having some sort of discrepancy. And if it's a family member who's operating the business, you know, usually there's one child who's got more involvement in the business than other children, and how is that child supposed to be treated? And are they going to be the manager? Are they intended to get 100% of the company? Are they going to buy out their siblings? All those things should be laid out clearly and allowed for in the operating agreement, and certainly best for everybody to be on the same page, because if there is lack of understanding on anyone's part, it's more likely to take it to a level of disagreement within the family, possible disharmony within the family, and having to go to the court for clarification, which is very costly.
I have one other, what may be a silly question, but I was just thinking about it in the scope and context of an LLC. Let's say, for instance, we have a husband and wife and a son and daughter, and part of the provisions of the operating agreement are crafted to mirror the estate plan of the parents. And it provides that in the event of the death of one of the parents, that they automatically absorb the other spouse's membership interest, or in the event of one of the children's passing, if they predecease their parents and their other sibling, that their interest is distributed amongst the remaining family members in equal portions automatically. If that is provided in the operating agreement, could that still somehow trigger some kind of estate tax or probate, or would that just be, you know, considered a gift for purposes of the LLC membership interest? Could that be implicated somehow in the estate at all? Or could we craft something like that where by operation of the operating agreement, it automatically just gets redistributed in that manner?
Well, the operating agreement would certainly be a contractual obligation that would control, and the personal representative of an estate would be obligated to honor. Whether or not it would be treated as a gift, I don't know that it would be treated as a gift, because during lifetime, if it's subject to change, then it can't be treated as a gift while you're alive, because a gift has to be complete for it to be treated as a gift. And if it's subject to change, it's not complete yet.
Right.
And if it's determined by contract, I guess it just depends upon, that's a little bit more complicated of a question than you might think, because it depends upon whether or not somebody retained too much control, and the IRS is going to come in and say, okay, you retained control of the company, but here you say you gave it up. We're going to deem you had sufficient control to make it taxable. So that would just depend upon the terms. But certainly the terms of the operating agreement would control who's entitled to what. So you could say, if so-and-so passed away, you agree this is the person who takes your place. And then your personal representative is obligated to follow those contractual obligations that you were under while you were alive. And as far as the tax implications, that would be addressed on a circumstance by circumstance situation.
Perfect.
And otherwise, yes, I think having somebody, a lot of people don't look at those operating agreements again and don't realize that they discuss what happens in the event of death or divorce, and many of them automatically allow for a transfer to your revocable trust without consent. But all those things need to be looked at before you think you can just willy-nilly put it into your trust, because you might think it's in your trust, and the operating agreement would say it's void and it's of no effect whatsoever. Or
Yep.
Worst case, that you've made the transfer and now you have no voice in the company.
Mm-hmm.
How about that? That's like way more than you would even anticipate. That, like, you stumped the swami. Now, can you talk a little bit about the kind of basic trust platform, and when do you use it? Sometimes I hear clients in the office, they're like, I don't have a lot of money. I don't really feel like I need a trust. Like, what would be a reason why someone would decide to get a trust or to avoid getting involved in a trust?
Some people avoid a trust simply because they've had experiences where they're overwhelming for people. And in some circumstances, I don't agree with Susie Orman that everybody needs a trust, because you basically, first you need to look at all of your assets and determine what assets the trust would control. Things like an IRA, annuity, life insurance, many times those don't go through a trust unless you intentionally name them as a beneficiary of the trust, or if you fail to name a beneficiary and they end up getting to the trust through the probate process because you never named a beneficiary. So some people's assets don't warrant to trust because their assets are going to pass outside of the trust. So always, first step is to list all of your assets, have a complete financial statement, and address it on an asset by asset basis. Then for the sake of a trust, the two primary benefits of a trust are that all assets owned by a trust avoid probate in the event of your passing, which means that during your lifetime, you have to retitle assets to your trust to be able to avoid probate. Many people think that if they create a trust, there won't be a need for probate, but the trust just gives you the vehicle to avoid probate. The next step is to go by asset analysis and determine, does this bank account belong in the trust? Does my brokerage account belong in the trust? Do I put my homestead property in the trust? And then all the assets in the trust can be managed by your trustee and will avoid probate in the event of your death. And some people, they want to have that continuity where their loved one doesn't have to stop and go through the court process before they can finish the administration of the trust. For some people, that's a guiding light for them, that they really want to make it easy for people. With that said, there's always a risk of probate. And if somebody were to die under circumstances, whether it be a wrongful death or medical malpractice, a probate's required in those circumstances. So we can never be 100% sure we're going to avoid probate. Another reason to create a trust would be that if you want to, and this could be a trust that's either revocable during your lifetime or the one I referred to earlier, trust provisions under a will. If you want to control the distribution of those assets, the management of those assets following your death for the benefit of a loved one, the trust is the way to do that. So, those circumstances I hinted at earlier would be mental health issues, drug or alcohol issues, gambling issues, spending issues, son or daughter-in-law that you're afraid that they're going to influence them. Unfortunately, the laundry list of things that can go wrong in a person's life are a lot.
Mhm.
So some people will utilize a trust to control the assets for their children's benefit. Some people, as of the last, I'd say 15 years, are using trusts more commonly so that their children can have this money available to them, but have it, because once you pass away, your revocable trust becomes irrevocable. The terms can't change. It can be a method of providing for some financial support to your child without a creditor being entitled to it because it's not your child's asset. So there's many different reasons why you might want to control it. Or some people, even with a business, that they want to be able to ensure for the first few years, the business is going to work a certain way. So we want to keep it in the trust, but ultimately distribute it out. Because as corporations and trusts, we have a 2-year period of time in which we have to work with before it has to convert to a C corporation. So it just depends on the level of control you want. And then depends on each individual situation. So in some circumstances where you don't have maybe some of those issues, but you just want to protect your children from creditors, in those circumstances, you could even say, my child's going to be trustee of their own trust, and they have the ability to appoint a co-trustee so that if they did have a creditor issue, they could appoint a co-trustee, and a creditor is only entitled to what the beneficiary is entitled to receive. So the trust says it's up to the trustee's discretion. There's no fixed entitlement to that beneficiary. It's determined on an as-needed basis, and the creditor doesn't have a fixed right to that money. But if it says the beneficiary is entitled to all income, the creditor could state claim and say, okay, those income distributions are supposed to come to us. Now, some people, though, with all of that said, they don't want to control their children's assets, and they want them to have freedom and will just distribute it outright to them. It's really such an individual situation. And then in other people, they just want, the most common scenario with trust documents, I would say, is to keep it in trust over staggered ages. And to say that, you know, until my child reaches a certain age, I don't feel that they're completely capable of managing all these assets. So the most common age distributions I have seen in the 22 years that I've been doing this is to say that at age 25, my beneficiary gets 1/3. At age 30, they get half of what's left in their trust. And at age 35, they get the remaining balance. And especially if your children are young, that, I mean, those are the terms I have in my trust. Although I might have increased it by because I don't believe people are mature enough until at least age 30. But and then as their children grow older, you know, when you do your reevaluation every few years, you can say, okay, my child's 25, and if they receive their share of this is $1 million, I don't want them receiving $300,000 if I were to pass away today, that you might have to then change the age distributions. And it's also quite common within trust documents these days to have what's called restricted behavior provisions, which are provisions that say if my child or beneficiary has a drug or alcohol problem, whether it be illegal or legal drugs, it doesn't matter, or if they have a gambling problem, or if they've been incarcerated, that the trustee has the ability to say, this trust might say you get income, but because I'm considering you to be somebody, quote unquote, under a disability, you're making bad decisions. And your bad decisions are you're going to the Seminole Casino and spending $50,000 a month. I'm not going to provide you with the distribution. The trustee has the authority to do that. And some people, you know, they don't want those provisions in their document at all because they don't want to insult their children and they don't want to anticipate that happening. And other people look at those provisions and are very thankful that those provisions are there. Because if their child is going, you know, derailed, it gives the trustee the ability to not fund their bad decisions. And then the trust provides language as to when those distributions can resume, when the trustee is determined that they're no longer under that disability.
And I think that's also, you know, what's nice about having a good estate attorney is they will discuss these different considerations with you, because I think many times folks will get this big stack of estate documents that looks like a Bible, and it's very daunting and overwhelming, even for an attorney to review. But having these discussions, even with my own husband, about what you were just talking about how much control do we want to retain over our own child? And he was of the mindset of, no, I don't want to insult. And I'm of the mindset, no, I don't know what is going to happen in 20 years. And he's 25. If he's going to the casino or he's abusing drugs or whatever, I want to have the ability to save him from himself. So I think that spouses can have very different viewpoints on this. And it's really good to have an attorney like you who will have this discussion with them, and you have the stories to share with them and the wisdom and the insight that, you know, if you're just a layperson or even an attorney like me reading these provisions, they don't mean much to you because you don't have any context, but you have that wisdom and, you know, you're guiding them more as an advisor as opposed to them just pulling these documents offline off LegalZoom or otherwise. So
yeah, by the time we finish our initial meeting, I usually know, I feel like I've known these people for years, really, my clients, you know, that we cry, we laugh, we go through a lot of emotions because it is it's your life's work and it's the people that you love. And, you know, the effort that some people are willing to go through. I'm probably one of the few attorneys who actually have men cry in their office because sometimes it's, you know, people care about their family so much that if they can't find the answer so easily, it's a very emotional process. But yeah, I'm never afraid for those conversations and never afraid to share even my own personal experiences, much to my husband's chagrin. You know, things that we've encountered or that I've encountered, because it hits home for people and makes people look at something differently and brings the conversation out so that people can iron out their differences. And luckily, many times people do come to a compromise. I'm never really fond of it when one throws their hands up and says, whatever, it's the way you want it. That never makes me feel comfortable. It happens every once in a while, but otherwise, most people, it's amazing to see the intimate conversations they'll have in front of me to try and reach these decisions. Because I think everybody really, if you're going through this, you're doing your best for your family.
Mm-hmm.
And that involves talking about things that hurt a little bit, or things that, that you don't talk about with your family and friends because it's not something you might necessarily be proud of, but it's just the reality of the situation. Because I'd say most people have issues they're dealing with, and it's the rare family where everybody gets along well and there's no special issues and they're all doing well financially, but thankfully those families do exist, but they're in the minority of the situation.
They're on the Hallmark Channel, I believe.
Yeah. I had a client trick her husband into coming in to just do a power of attorney, intending to do a full will, and an elderly couple. And when I started to get into those topics, he got so angry. And I said, I'm not here to sandbag you, but if we could discuss this, we could get it all done. And we were able to get it done. But she really did sandbag her husband because he thought it was just say who's going to be power of attorney and we're out of here.
Oh,
and
wow.
Then we had to talk about if this person dies and that person dies. And he didn't think anybody was going to die. But we were able to get it all done. And they're still with each other, which is always a good thing, because it's always my goal to try and bridge the gaps where people are, and to try and find the silver lining where we can within relationships, and to put pen to paper as to what people's wishes are to the best of my ability, and with the intent of those people still being intact even when their mom or dad or loved one isn't here anymore. But yes,
Right.
it's that controlling assets from the grave can be quite complicated. And some people want to control all of it, and some people don't. And some people just, and some people, everybody's got their own opinions. Some people want to know that their child's going to have everything they need. And some people who say, no, I don't want them to have a fixed dollar amount. I just want this to be there if they need it. I don't want them to be dependent upon it. So it's everybody's individual thought processes and their emotional attachments to their loved ones and to the assets they leave behind that ultimately decides how it's going to go. And sometimes I don't think people necessarily know until you start having a conversation, because it'll be fine. And then you say, well, what if they get married? Oh, and what if you don't like the son or daughter-in-law and they're in their ear telling them to do this? Well, that changes everything, and it's so specific to each person's individual circumstances. But generally there's that 25, 30, 35 and allowing people to go about their wishes after a certain age is probably the most common way a trust looks. But I think you have to kind of look at every individual beneficiary and each of their needs. Some people won't treat any child differently. And even though there might be a child with a need that would, dictate keeping it in trust, they don't want that child to think they were treated differently than their brothers or sisters. They don't want their brothers or sisters to be responsible for doling it out to them or determining if they're entitled to it. So sometimes people just completely ignore all of that and distribute outright, even if there is a child in need, to keep the harmony amongst all of their children, so it doesn't seem like somebody's been singled out. It gets complicated.
It does get complicated.
Well, it's of course complex legal issues, and now you throw in emotional family dynamics more than any other area of law. Like what could possibly go wrong?
Yes. Well, and then, and I meant to say this earlier, and if you don't have any of these things in place, without the power of attorney and healthcare surrogate, you have a stronger need for a guardianship. Without a will or a trust, I want to quell the thought that the state takes your assets. The state doesn't take your asset. The state just determines who receives your asset by what they consider the normal progression of who should receive, your heirs at law. So if you're married, it's going to be your spouse and possibly your children if you don't have a will or a trust, depending upon whether or not it's the children all belong to the two of you will determine the allocation of what your spouse gets and your children get. If it's all your children, the spouse gets 100%. If it's not, they'll split it. If you don't have a spouse and you have children, it'll go to your children. If you don't have a spouse and you don't have children, it will next go to your parents, and then it goes to your siblings. So there is a provision that even if you don't have a will, some people will think that they have to have a will and that the state's going to take their assets without a will, but that's not the case. And some people, they feel so much relief when they learn that if they don't have their will in place, the Florida statutes give their assets to what they consider their natural heirs. And many times the Florida statutes mirrors what people intend to occur anyway.
But that's still not an excuse to not do this.
No, and only 1 in 7 people have their estate planning documents in order.
Wow.
It takes years. I mean, for me alone, it took me, I'd say 7 years to get my husband to sit down to do an estate plan. We could not agree upon guardians. It always ended up in an argument, and it wasn't worth the fight.
Who can argue with you? Like this
I know.
This is Kate's like most fierce battle voice. Like, well, I think that it would be preferable to have like that's how you like fight. I can't imagine arguing with you. What is he doing?
Why it took me 7 years. And I contemplated doing my own documents that reflected my own wishes, to be honest. But then that brought me up against marital issues, and I couldn't get myself to do it. And it was finally my going into surgery that I was able to, put more heavy of a foot down and get him to sit down. And then since then gone through then once we had it in place and saw things change, say, okay, remember that person? We don't want that person. And so now we're in the process of updating our documents. And there's less, once we got over the initial hump of our disagreement, we have much less disagreements now with it.
Oh yeah. It's very much like going to the gym. Once it's done, you're like, I don't know why I didn't do that sooner. Like it wasn't that bad and I do feel better. And there is some peace of mind knowing that it is all settled and that you've kind of done right by your heirs to say like, this is not a disaster that you have to clean up.
Yes. Yeah. And there's things like even not within the trust document that people don't think about. And people have complicated situations and personal situations that sometimes the trust document can't speak to it. But a trust is intended, and the will, both are intended to carry out your wishes. Mm-hmm. So my clients in those situations, I will encourage them to write a letter that either I keep with the will in my safe and it only gets broken out when the will is broken out or the trust is broken out, to give further clarification and guidance to the trustee or to the beneficiaries to explain why they did what they did. That's a very small percentage of people who do that. But I had people in recently that they were doing something kind of out of the ordinary and for very good reasons, and didn't want to necessarily have it in a trust document, which is intended to be a private document. But as you know, Joanne, Jackie.
Yeah, we prayed that thing all over.
Yeah, people are asking for the whole thing all the time and they won't take a shorter version. And so some of these things aren't meant for in a trust document. But if we have other things that evidence your intent, the trustee can use those for guidance and not necessarily make them information that just anybody can access. So if there's more of a complicated situation, I encourage people to do that, or to give explanation as to maybe why they kept something in trust versus somebody else's, or the determination under which they want their child to make distributions for their brother or sister, that you wouldn't put all of that personal information in a trust document. So there's other avenues to educate your beneficiaries and your trustee that can be used as guidance, that doesn't have to be contained in the trust too. So people are aware of that they can keep it private as long as they want it private until it needs to be disclosed.
Right.
Wow. I think that's a lot. And I think it was fantastic. Do you have anything else that you feel compelled to get out there in terms of other points that you have?
Well, no, I think we covered the basics of everything, and just realize, that there's different forms of trusts. A revocable trust, you'll also be heard, it'll be referred to as a living trust. Those two documents are similar, versus a testamentary trust, which is not a trust at all, but a will that contains trust provisions. And that's the document I recommend at a minimum for anybody who has minor children. Oh, because under Florida law, if a minor child receives assets in excess of $15,000, those assets have to be subject to a court-appointed guardianship if they're not subject to a trust. So if minor children are involved, trust provisions are necessary to avoid the need for a guardianship.
Wow.
Yeah.
And otherwise, there's a lot of different things. We didn't get to any of the tax implications or some of those issues, because those could be a discussion all on their own.
And those will just scare us all into our grave.
and
We were scared enough.
Yeah, we don't know where we're going with any of it. Right now, everything's kind of on a standstill. There's been threats to take away step-up and basis. There's been threats to reduce the exemption amount. Even if they don't reduce the exemption amount now, it's scheduled to be reduced anyway. It's going to sunset in 2026. So right now, our exemption amount is $11,800,000. But if nothing changes in 2026, it's going to go back to the law before Trump changed it. And it's going to be somewhere between $5 and $6 million unless they change it more, which in today's economy, a year and a half ago, that didn't concern me. But now when you mix their reducing the exemption amount and our inflation, it could make it that states that weren't taxable could be taxable. And in those circumstances, those trust documents need to get more complicated to allow for family trusts that utilize the estate tax exemption amount and marital trusts that utilize the marital deduction, and have it broken up to maximize estate tax. But that gets more complicated, and we need to get.
Well,
And yet another reason why you need to go back to your state attorney on, every 3 to 5 years at least.
Yes.
Yeah, because then you're not trying to plan for whatever tax implications might happen in the next 35 years, because you're kind of keeping up as basically every time the administration changes, the tax code
Every 4 years.
The tax code is the fire hydrant, and everyone needs to make their mark on it. So it doesn't matter which way you lean, there will be somebody's going to want to have to say something about the tax code. So fortunately, Marina and I have perpetual employability, because the tax code will forever change. So by the time we've mastered it, the new one comes along. Hopefully the next new one doesn't come in the middle of PPP.
Oh my God, God help us.
Oh my
We
God.
have no need for more PPP.
No more PPP, please. We would like to bring you back and talk a little bit about those estate tax parameters and things that we should be mindful of, at least on a basic level, if you'd like. Especially for those who didn't take advantage of the unlimited exemption like George Steinbrenner did. If you didn't already die when it was unlimited, you need Plan B. So he picked like the perfect time. So and thank you so much, Kate. We really appreciate it. Your knowledge and you're a gentleman and a scholar, and we love working with you. And I finally signed my personal estate planning documents last week, dragging said husband behind, who tried to tell her in the meeting that he was forced to come. Through his giggles.
For all these spouses claiming that in your office, Kate.
I was like, I don't know. Like, what's going on at Kate's office? So anyway, thank you so much, folks. Please, next week, we are going to have Marina on with John Cipher. If you want to hear about 7 critical numbers for your business and what to be on the lookout for, what your numbers are, how to calculate them. These are things that are not just financial statement driven. So if you want to have something to leave behind, you should check this out. And Kate will plan for it beautifully. So as always, like I said, these are recorded and distributed. So if you want to run this back, this was certainly quite a bit of information. If there's something you want to share, you're welcome to. If you have ideas for other topics you'd like to hear about, we're all ears. So do please let us know. Thanks so much, Kate and Jack. We will
thank you
next Tuesday.
Thank you.
Thank you.
Take care.
Bye, guys.
You too.